Commission could face challenges to a number of cases currently under investigation or already referred to the Competition Tribunal. This follows the Supreme Court of Appeal's decision to overturn rulings against milk producers Woodlands Dairy and Milkwood Dairy for allegedly fixing prices of raw milk. So what kind of a precedent does this set? For more, I'm joined by Robert Wilson. He's partner at Wentzel's competition practice. Robert, thanks very much for coming in today. Perhaps starting at the beginning, why did the court set aside the complaints against those two dairy producers?
Stephen, thank you. The Supreme Court of Appeal set the initiation of the complaint aside, a 2006 initiation in terms of which the Competition Commission gave notice of its intention to investigate alleged conduct, cartel conduct in the milk industry, and specifically cited these two respondents. The case is somewhat complex in that the initiation of the 2006 case found its genesis in a 2005 initiation of a complaint, which subsequently was not referred to the Competition Tribunal for adjudication. Fundamentally, the 2005 case was flawed. It was overly broad in its parameters, and various summonses that were issued under that 2005 case were found subsequently by the Tribunal and the Competition Appeal Court to be vague and overly broad. Coming out of that, the 2005 case wasn't proceeded with by the Commission, but then the Commission subsequently decided in 2006 to initiate a new complaint, relying on evidence that it had obtained under the flawed 2005 summonses. And it was on the basis of this reliance of tainted evidence, so to speak, because of the procedural irregularities, that the Supreme Court of Appeal decided that the 2006 initiation had to be set aside, and also the referral to the tribunal. I must point out, however, that it was only in relation to these two respondents that the Supreme Court of Appeal set aside the initiation and the referral. The case still continues regarding the other respondents.
What sort of precedent does this set, and what really is being drawn into question? Is it the broadness of the parameters that are being drawn into question here, or is it the fact they were choosing to go back to an earlier case that they hadn't followed through?
But there are two important points here. The first is that coming out of the Supreme Court of Appeal's judgment, a very restrained judgment, one might add, clearly the court wasn't happy with the manner in which the Commission had conducted itself. There are a number of references to the Commission effectively overreaching itself and its investigative powers being used in an improper manner. That's a more fundamental aspect to the decision, and the Commission would be well-minded to have regard to the principles laid down by the court. At a more technical level, a rather complex technical argument as to whether in fact the Commission had properly used evidence that had been obtained under the tainted summonses. One has a certain sympathy for the Commission, because in essence the court was saying that in order to initiate a complaint lawfully, one has to have regard to so-called jurisdictional requirements. The Commission needs to be seized of a certain degree of information in respect of which it then has a reasonable suspicion to initiate a complaint, to investigate that complaint, and to use its investigative powers that it has under the Competition Act. For example, to issue summons against individuals to come and give evidence or effectively be interrogated by the Commission, and also to produce certain documents. And so in essence the court was saying that if the Commission is to make use of these investigative powers, its very starting point needs to be properly defined, because in essence one cannot go beyond what you initially state is going to be your case. Certainly what the court subsequently said, or said in its judgment, was that that doesn't preclude the Commission from then naming new respondents or initiating subsequent complaints and in effect bringing them all together by way of a consolidation later on.
Of course, we know the Commission is considering whether to take this to the Constitutional Court to maybe overturn the decision that was taken by the Supreme Court. In the meantime, do you think this opens up perhaps the way for other companies who have been investigated by the Competition Commission to also go to the Supreme Court and look for similar loopholes?
Well, in the first instance, one has to recognise that this is a very unique set of circumstances giving rise.
So it wouldn't necessarily apply to other cases?
Not necessarily, by virtue of the fact that the court set aside the decision because of the reliance on the evidence that was obtained during the course of the 2005 case and the summonses that were defective. So the circumstances are very unique. It's not necessarily the case that this is now going to lead to a floodgates of respondents both currently under investigation or currently before the tribunal seeking to have the complaint set aside in respect which they are cited. Certainly, however, one would expect respondents to these proceedings to now go back to the very initiations to carefully consider whether in fact the Commission's initial initiation was possibly overly broad. But one has to recognize that by the same token, the Commission rectified what was in essence a poor case to start with.
In 2005, yes.
In 2005. So one would expect that it's learnt its lessons way before now.